Hey there, good morning and good Saturday morning to everybody out there. Thanks for joining us today for another episode of A Snowball's Chance in Healthcare, a show about restoring hope in healthcare and through practical and common sense solutions. I'm Josh Butler, your host, and I'm also the president of Butler Benefits and Consulting here in Amarillo. We are a boutique healthcare consulting and brokerage firm, and we're focused on scaling innovative solutions that lower the cost of healthcare for both employers and their employees. And we frequently talk about tactics and strategies, and we tell stories and give advice and tips on how to dramatically lower the cost of healthcare. And today, we're going to be discussing what I feel is a very monumental case. It's a monumental Colorado Supreme Court case that I believe, and many others believe this, by the way, that will have a long-lasting impact when it comes to what people and what companies actually have to pay for healthcare-related services. Okay, now last week, I'm going to reference last week's show quite a bit today, but I want to start with a question. So when you receive medical care, you get a surgery, or you have to stay in the hospital or something like that, are you responsible for paying just any price, whatever amount a hospital or the doctor decides to charge you? So if they decided to charge you $1 million for a surgery, do you owe it? Do you legally owe it? What if a hospital tells you that prior to a surgery, that your expected price or your expected out-of-pocket amount that you're going to be personally responsible for is going to be $1,300. But a few months after your surgery, you get a bill from that same hospital for almost $250,000. So imagine that. Do you literally owe it? Okay. Now here's my next question. What's the same question is, do you literally owe it? But here's another question. What do you do when the hospital sues you when you can't afford to pay it? They sue you in court to collect $230,000. Well, if you live in Colorado, we know the answer to that question because that's exactly what happened to a woman from Colorado. Her name is Lisa French, and this was a case that made it all the way to the Colorado Supreme Court. And in 2014, Miss French received 2 surgical procedures at a hospital, and it's named St. Anthony's North, and it's located in Westminster, Colorado. Okay. Now, St. Anthony's North is part of a larger hospital system called Centura Health Corporation, which is also based in Colorado. Now, for the record, so everybody knows, St. Anthony's North is a nonprofit hospital, a Catholic nonprofit hospital. So this is a Christian-based nonprofit hospital that sued Miss French in an attempt to collect $230,000 for her surgeries after they misread her insurance card. So now I know this took several years. This was all the way back in 2014, but it made it to the Colorado Supreme Court, who just a couple of weeks ago unanimously ruled that, in fact, neither Miss French nor her insurance owed St. Anthony's North this $230,000. So we're going to dig into this story a little bit today, and we're going to talk about the implications that this court case has on both employer plans and even the uninsured populations in our communities. So I believe that this is a landmark case, and we're going to talk about why it's so important for employers to know about this case and other people around the country to know and be aware of this Supreme Court case, because it sets a precedent, right? It's all about setting a legal precedent. And I believe it's going to serve as a cornerstone to protect consumers into the future, protect consumers from predatory billing that we know exists in our healthcare system, okay? And we're going to talk a little bit more about that. Now, so back in 2014, what happened is Miss French was involved in a car wreck, and she had some pretty severe injuries, and she was going to need a couple of back surgeries, a neck surgery and a back surgery, to get her all fixed up. And she had been given an estimated price from St. Anthony's, from this hospital, in the amount of $1,337. Okay. Now, Ms. French also signed multiple hospital service agreements that said that she would be responsible for, quote, all hospital charges that her insurance didn't pay. Now, keep this in mind because it's a key part of what we're going to discuss today. So she signed an agreement that said, I'll be financially responsible for charges that my insurance plan doesn't cover, okay? So the hospital was claiming at the time that they had misread when they gave Miss French this $1,300 estimate, that they had misread her insurance card, and that in fact Lisa was an out-of-network patient, that the hospital was an out-of-network hospital. Okay, so the total bill for her surgical procedures, they were over $300,000. Okay, well, Mrs. French's insurance was her employer. She worked at a company that was self-insured. They were self-funded. We spoke about that last week. Now, her insurance company, or AKA her employer, paid over $74,000 for Miss French's 2 surgical procedures. So despite that hospital being out of network, they still got paid $74,000. So remember, this is also a key point. It's not like this hospital got shirked. It's not like they got paid zero. Okay, they got paid $74,000 on Mrs. French's procedures. Now, the hospital had argued that they had a contractual agreement with Miss French because she had signed these services agreements stating that she would be responsible, personally responsible, for all the charges her insurance didn't pay. But the court ruled that because no specific prices were ever shared with Miss French and no specific prices were ever mentioned in those services agreement, that she wasn't responsible for them. Okay? Now, hang on a second. What the court is saying here, which has arguably been a long-established concept in contract law, is that the price must be mutually agreed upon by both parties for there to be an enforceable contract or an enforceable agreement. It's called mutual assent, and they use this argument of mutual assent all throughout this case. And in the court opinion, they go back and reiterate mutual assent multiple times. We're going to come back to it again a little bit later. But I want everybody to think about this. Could this be the beginning of legal protections that say, hey, listen, hospitals, you can't just charge us whatever you want to charge us and expect us to pay the full price tag. You can't just ask people to agree to be responsible for any charge or any amount beyond what their insurance pays. I mean, if that were the case, think about the implications of that. Why didn't they put $1 million on the hospital bill and said, well, heck, your insurance only paid us $74,000. You owe us another $930,000. Why didn't they put $1 million? And there's reasons behind that we're not going to get into today. But it's this point alone that I think lead most people to feel like the snowball in healthcare. They're very frustrated. They don't feel like they have a say in what actually gets paid for healthcare services, or that maybe a big hospital system like Centura has all the leverage. They feel overwhelmed, and in many instances, they feel intimidated, okay? Right? You don't think it's intimidating to be sued by a large hospital system? Of course it is. These are intimidation tactics. Things like turning people over to collections are also intimidation tactics. And that's why this court case is so important. It balances out, where one person, they don't feel like they can stand up to a large hospital system, and the court, that's what courts are for. So that's a huge point for people to just remember, is that courts are there for a reason to help protect people against things like this. Now, during the trial, there was an expert witness that was a key expert witness for Miss French that had estimated the cost, now not the price, but the cost to deliver the services to Miss French by St. Anthony's to be approximately $70,000. The cost, not the price, okay? So that's important too, because we see here that the hospital got paid $74,000, that they actually made a profit. It's not like they lost money on this deal. They actually made, according to the court records, a 5.5% profit margin on Miss French services. Yet they were still suing Miss French, trying to seek an additional $229,000. Now, you might be asking, why was the price tag so high to begin with? Well, remember, I talked about this last week on last week's episode when we talked about the difference between a hospital's price and a hospital's cost. Remember, hospitals use what are called charge masters, and charge masters were referenced a bunch in this course opinion. And these charge masters are massive, massive files of billed charges to establish what actually gets paid by health insurance companies. But like I said last week, charge master rates have little to nothing to do with what a hospital's actual costs are. And it has everything to do with maximizing their profits that are negotiated through these contracts with insurance companies. And guess who else agreed with me? The Colorado Supreme Court agrees. The justice writing the opinion for the Colorado Supreme Court, that's Justice Richard Gabriel, stated, quote, "Charge master rates have become increasingly arbitrary and over time have lost any direct connection to hospitals' actual cost, reflecting instead inflated rates set to produce a targeted amount of profit for the hospitals after factoring in discounts negotiated with private and governmental insurers." That's exactly what we talked about on this program last week. Now, like I said, Mrs. French's surgeries took place all the way back in 2014, back before it was a federal law that hospitals had to disclose their charge masters. This is back in a time when hospitals were still arguing that their charge masters were proprietary and confidential information. So for Miss French, they never shared anything with her, much less the charge master prices, and so nothing was shared with her. Excuse me. Now, one might argue that all hospitals have to do today to avoid losing lawsuits like this is to simply provide their charge master prices to the patient or make their charge masters readily available on their websites, et cetera, et cetera. Well, not so fast, because also in this court case, the Supreme Court also said that even if St. Anthony's Hospital had provided the charge master rates to Miss French, their charge master had over 50,000 lines of almost undecipherable language. It would have been, quote, impossible for her to decipher or to understand. And today hospitals have to post their charge masters online, and most hospitals do. But if you've ever gone to a hospital's website and pulled their charge masters, most of them are impossible to read, especially for lay people that don't work within the industry or specifically at that hospital. And so during this court case, even Centura Health, they acknowledged in court that Miss French, there's no way she would have been able to decipher the 50,000 lines of their charge master. So it's clear, even if St. Anthony's North had shared their charge master prices with Miss French prior to her surgery, it still wouldn't have changed the court's ruling in this case. Also in the written opinion, the court also reestablished this concept of mutual assent in contractual relationships, stating that both parties must mutually assent to a price in order for the contract to be enforceable. And it's this premise that people really need to embrace and remember. Hospitals can't just arbitrarily charge us whatever price they want. And when prices are not agreed upon in advance, that courts can step in and juries can step in to determine what is reasonable, what is valuable, and what is fair, okay? And that's the court's opinion. This is extremely valuable, okay? Now, the expert witness, the same one who estimated that St. Anthony's costs were around $70,000 for her procedures, that same expert witness testified that the billed charges, the $230,000 that they were trying to collect from Miss French, were, quote, they greatly exceeded their reasonable value and were unreasonable. And that the $74,000 that was paid by French's insurance was, quote, very close to reasonable value of services that French received, which gave St. Anthony's Hospital a 5.5% profit margin. Okay? Now, guys, if you don't realize this, this is monumental, because here we have a state Supreme Court that's saying we're going to use costs, not charge master list prices, as the basis for establishing reasonable value and reasonable charges. Now, this to me is a legal precedent to support certain types of health plans, health insurance plans that are built on a cost plus model versus a discount off billed charges model. Remember again, last week's episode when we talked about network discounts or PPO network discounts. My question is, what impact is this ruling going to have even on big insurance companies and the way they negotiate discounts with hospitals? It's a big question. And this ruling, puts its thumbprint all over it. It also shifts the paradigm. And I know that it's a state ruling. It's not a federal ruling, but it is legal precedent and it's been established. And so when you have a hospital that's saying, look, you owe me $300,000 for this procedure, but you have a payer saying, no, we only owe $74,000. That's a big gulf. That's a big difference. And so somebody's got to step in, and that's what courts are for. And that's what this court did. And in this situation, the court decided that what the insurance company was willing to pay was reasonable, while what the hospital was seeking to collect was unreasonable. Now, that's a big deal, and that has big future implications into how employers purchase healthcare plans, okay? So if you're an employer, I want to ask you a question. Are you aware that there are health plans out there today, right now, where the fee schedules and the payment schedules are already established based on healthcare costs and not charge master list prices? Those plans exist already. And that's what makes the Colorado Supreme Court ruling so significant. If this is the beginning of establishing legal protections for patients where over what gets paid, and that's established based on cost and not price, well, this legitimizes every single healthcare plan that exists in the market today that's already calculating their fee schedules based on costs versus price. And it's big money, folks. It's big money that can be saved in these types of health plans. Look at Mrs. French's case as an example. It's literally the difference between owing $300,000 for a procedure versus only owing $74,000 for a procedure. So if you're an employer, or perhaps you're an HR manager, if your company's interested in looking into plans that pay benefits based off actual healthcare costs and not hyperinflated prices, feel free to contact me. Reach out to me. I'm happy to discuss these details. You can call me. You can connect with me on LinkedIn, or you can go to our website, which is butler-benefits.com. We've helped a lot of employers. We assist many employers with this very specific type of health plan, and it's a great way for companies to reduce their healthcare and benefits costs. Now, in case you just joined us and you just turned the dial over to 710, we've been discussing this Colorado Supreme Court case where a woman was billed almost $250,000 for a back surgery after the hospital told her that she was only going to owe $1,300. Well, the Colorado Supreme Court ruled just a few weeks ago that she didn't owe it, and neither did her insurance, despite her signing an agreement that said she would be financially responsible for all charges beyond her insurance, but beyond what her insurance had paid. So the court used a lot of reasoning in this, and all of the reasoning goes back to issues that we've discussed on this program before. It goes really back to the way healthcare is bought and paid for in this country. And the vast majority of healthcare is still bought through a process of discounts off prices instead of marking prices up over cost. There's a big difference there. Now, I've shared some impacts and some implications that this ruling is having and going to have, that what we foresee they're going to have on employer-sponsored group plans, and how I believe it's going to kick open the door of opportunity for employers to vet and participate in much more affordable, much more flexible health insurance plans in their organizations, plans that are based off costs, not prices, okay? But I want to add this, okay, because charge masters and charge master list prices, they don't impact just group health plans. Chargemaster rates also disproportionately impact uninsured patients in this community and in every community, because when someone is uninsured and they have a medical bill, that medical bill is based off the Chargemaster list price, and the uninsured patients fall through the cracks and they're always stuck being held responsible for Chargemaster rates. Now, they're typically offered minuscule, what we call cash discounts off Chargemaster rates. But this is another big question that we still don't know yet, is that will this ruling alter the way that cash-paying patients negotiate with hospitals? It's a great question. What are you going to charge me? And if you're trying to give me some, meaningless discount off of the bill charges, are they going to be able to reference these types of rulings to say this price isn't fair, it's not reasonable, right? Time's going to tell. Will hospitals start to treat uninsured patients a little bit more fairly when it comes to cash pay discounts? That is yet to be seen. Now, I hope that's the case, right? But one thing is for sure, okay? Now there is a strong legal argument that can be made that what a hospital chargemaster says is pretty much irrelevant, okay? It's pretty much irrelevant. And when there is not mutual assent between two parties, that courts are going to have the authority to step in and ultimately define what is fair, what is reasonable, what is equitable, what is valuable, and that they're using costs, not prices, to make those determinations. Okay? Now, when I think about this really deeply, this is where I get a little bit upset about it. I get a little bit passionate about this, is when you think about how many people out there over the years have been impacted by a medical bankruptcy, or perhaps they've been turned over to a collection agency simply because they couldn't afford to pay the list price, the Chargemaster list price, not the cost. Here's the question. Had their debts been established based on actual costs versus the Chargemaster list price, maybe they could have paid them. Maybe they could have avoided a bankruptcy. Maybe they could have avoided bad debt. And that's really the tragedy. And that's why these cases are so important. It has a very large human impact. Now, I know that there's going to be some people that have a completely different take on this Colorado Supreme Court case, especially hospitals, right? They're going to say things like, well, this is price fixing. And this is the government basically telling hospitals what they can charge and what they can collect. We're private hospitals. We can charge whatever we want. We can collect whatever we want. And, they might even say things like people who support this Supreme Court case, they want to see hospitals go out of business. This is going to force hospitals to close their doors. Well, look, nobody, no one, including myself, including the Supreme Court of Colorado, nobody wants to see hospitals go out of business. Okay, this is a straw man argument. It can't just be all or nothing, right? At the end of the day, folks, and I think most people would agree with me when I say this, at the end of the day, people want to be treated fairly. Businesses and patients, they just want to be treated fairly, and they want to be able to conduct business transparently. So these are the types of things that we can have a happy median here. It doesn't have to be 300,000, but it doesn't have to be under 7. I don't want hospitals to lose money. I don't want this to be misconstrued. But making information available to patients before they have surgeries, that's not too much to ask. Giving people an accurate estimate of what the total price is going to be before a service is rendered, that's not too much to ask. So I just wanted to make that point that we don't want hospitals to go out of business. I think people just want to be treated fairly and they want to conduct business transparently. And so since this show is heavily geared towards employers who sponsor group health plans, I'm going to make it abundantly clear. Legal cases like this Colorado case, things like the Consolidated Appropriations Act, and all of these other transparency measures and regulations that are coming into effect. Guys, the handwriting is on the wall. If you're not listening, if you're not hearing me, the handwriting is on the wall. Now is the time for employers to be looking into innovative and alternative solutions to status quo healthcare plans. Now's the time. This is a tremendous opportunity to impact the lives of your employees in ways you haven't been able to in recent years. Plans that calculate their payments based off costs rather than prices. These plans are lowering prices for employers anywhere from 20 to 40%. And in addition, we can still implement plans with tremendous, valuable, and incredible benefits. Things like $0 deductibles, $0 generic medications, $0 outpatient surgical procedures, and so much more. Okay? So if you would like to have the full Colorado Supreme Court opinion, you can email me at info@butler-benefits.com. That's info@butler-benefits.com. Until next week, my name's Josh Butler. I'm the president of Butler Benefits and Consulting right here in Amarillo, Texas. And each week, I am arming employers and their employees with information that they need to have a snowball's chance in healthcare. Have a great weekend, everybody.
I'll say peace out.
Peace out. 2550.
Perfect.
That's it.